Okay, so you got some idea regarding copyrights. Just like say, uh, uh, what is copyright? Then what is the domain of copyrights? Okay, then what criteria a work should meet to get copyright protection? Okay, so now if I ask a silly questions to you, whether translation of a literary work will be considered an original work, what will be your answers? I will say answer will be yes. Translation can be original work, but the right to translate have been provided to the authors, okay, or let us say owners. Okay. What I want to mention, that is okay, just like say a work and translated work, translated work. So we are getting two work, one work, translated work. So I will consider this is original, this is also original, but you have to take permission from the, if you don't permit, don't take permission from the original work, owners of the original work, that will not, you will be treated as an infringer. I will answer those questions. So what I want to mention here, that we are getting two word here. One is authors and another you may consider owner. When we discussed about the patent, we have come across the two word, inventor and patentee. In respect of copyright, we have another important parameter is author and owner. So when I was I am discussing that copyright registration procedure, but to start that part, you should get an idea regarding that authors and owners. Just like say the when I discuss the patentee, means patentee is considering the owner, then in respect of copyright the creators will may consider just like inventor, the who invent, the so authors who just like say who create that work. I can consider who write a poem, just like say, oh, who is the authors of that poem, who wrote that poem, who is the authors, who is the writer of that script, means who wrote that script. So means that who is the authors of that painting, who created that painting, understand, who is the authors of that musical notation, so who created that musical notation. So like this way, so authors one part, so who create that work, who wrote that work, who wrote that poem is considered as the authors. So here also we are getting two terms, authors and owners. So okay, so now in respect of copyright, I will try to discuss that fact first before going to the discussion on say registration procedure. Okay, so Act has suggested the authors of the work is the first owner of the copyright in the work. So who is the first owner of the copyright in the work? The Patent Act has not mentioned clearly the rights of the inventors. They have mentioned the rights of the patentee. Here also they told initially copyright. They have not mentioned copyrights of whose, authors or owner, or who will be the authors or owners, but Act has mentioned author of the work is the first owner of the copyright in the work. So is there any chance of second owners? Okay. So definitely for that reason that assignee, assignment, sale and other elements is there. So for that reason that only author is the first owner of the copyright. So exceptions are there, exceptions are all there, except to the any, just like Act, if you read the section 17 of the Indian Copyright Act, the author is the first owner of copyright except to the any agreement to the agreement to and to contrary. Yeah, so authors always the first owner of the copyright. Of the copyright, except to the any agreement to the contrary. If there is an agreement that suggested that the ownership should be vested to the another party, so then the ownership should go to that persons. Otherwise, author is the first owner of copyright. So, just like that, your employee employer agreement suggested that in the course of your employment, if you generate a software or a poem or a painting, you have to assign the right with reference to that work to your employer. So, in that case, the say ownership should vest to the employer. Okay. So, for that reason, they have Act has created the provision of that any agreement to the contrary. So, regarding that, just like say I am referring that author is the first person who actually writes, compiles, composes or draws the work in respect to literary work or artistic work. Just like say who is the authors who actually writes, compiles, composes or draws the work. Author of the cinematographic film is the producer. Author of the sound recording is producer. Author of the photograph is the person who is taking the photographs. That I am referring. So, the person who writes that poem is considered the authors. If that authors will be the owners if there is no agreement to the contrary. Okay. Here lies the issues with reference to the authors and owners. Just like say I told you copyright exists on something fixed in a tangible medium, and copyright does not protects idea. So, now let us say Mr. X has been sharing some idea of video games with his friends. Later on, taking that idea, one of the friends, Mr. Ram, has created a video games. Okay. So, now who will be the authors of the video game and who will be the owners of that video games? In that case, the person who has expressed the idea in a tangible medium will be the authors, and author is the first owner of copyright. So, out of those people, if those people who has from those idea, that idea, if idea is not shared without any agreement or considering the confidentiality part, even that is different issues. So, in that with respect to copyright, the authors will be the person who has converted that idea in a tangible medium. Okay. So, the authors will be the person who has converted that in a fixed that in a tangible medium, that Ram has converted that video games in a tangible medium. So, then Ram will be the authors and he is the owner of that copyrights. Okay. So, similarly, let us say here the important part in copyrights are there, just like a authorship and ownership, series of cases and case laws are there. And that say the agreement to the contrary, considering that they have created an expression for that is sometimes called contract of service and contract for service. Okay. And just like a contract of service, I will put that. Okay, a newspaper organization, they employ so let us say Mr. X, Mr. Y on permanent role, and also they have appointed on temporary basis for on job for supplying some news item to Mr. Z. Let us say Mr. X and Mr. Y is under the purview of contract of service under the employee employer contract. Means that say sometime we referred as master servant agreement. So, contract of service, contract for service is also governed by one factors, means degree of control. Okay, degree of control. Okay, so if contract of service and for service, that part means, let's say sometime we call master servant agreement. Now, what are the degree of control that employer can exercise, or the person who has executing that contract can exercise to them. Okay, if they are under say under their under master servant kinds of situation, means whatever way the master is telling that servant has to follow that, then they are under the contract of service. We may refer our degree of control is higher here. Then contract for service, say in that case degree of control we may consider less, specifically situation to situation. Let us say Mr. X and Y and under permanent role, so they are supposed to provide the material to the newspaper or publishing organization as their boss, means that employer is suggesting, and Mr. Z has hired, or Mr. Z is a freelance news reporter. He is just like a freelance, means he is providing report of let us say some report with reference to cricket match, and he is freelance. He is providing a report to Mr. newspaper item A, Ms. Telegraph, Sportsman, and Telegraph, Statesman, and Times of India and others. So, he is not directly under contract of any of those newspaper under degree of control of newspapers. He is freelance writer, so he is providing write up to Times of India, write up to Statesman, write up to the Telegraphs. So, in that situation he will be under contract, or maybe under the contract of for service. In that case, the authorship and ownership of those his write up may lie with the with Mr. Z only. In respect of Mr. X and Y, yes, they are under the direct degree of control of the employer. In that case, ownership authorship would lie with the Mr. X, Mr. Y, but ownership may shifted to the employer. In that case, second case, Mr. Z is the authors and owner with reference to the script whatever he has been writing. So, here nice way you can create different kinds of case studies. So, understood that corporate case study I may let us say create, let us say with reference to the newspaper item itself. So, let us say Mr. X and Mr. Y is a permanent employee of a newspaper called Telegraph. They are providing some script news item in the form of a script. So, news item I can not the facts part they are representing in the form of some expression, and they are sending that script or expression to the editor of the newspaper. Okay. Now, editor of the newspaper is doing editing, and edited version is published by the newspaper called Telegraph. Okay. So, now if I ask that script item, who will be the authors and who will be the owners of the published news item. Okay. So, now if I analyzed the owners, we should go to the based on the contract of service ownership, because editor is also maybe under purview of contract of service or employer agreement with the Telegraph newspaper. So, that based on the contract of service that ownership should go to the Telegraph newspaper, and authorship should remains with Mr. X, Mr. Y, Mr. Z, maybe not Mr. Y and editors depending upon the situation. Okay. So, because if that editing say instead of editing, just like say the editor is doing just like a mere robotic contribution kinds of situation without involving his intellectual components, then the authors are Mr. X and Mr. Y. Otherwise, I will put Mr. X, Mr. Y and editors are the authors, and the ownership should goes to the Telegraph newspaper itself. Okay. So, got the thing, just like say authors and owners part. This is important part. Why important part? Because for registration of the copyright, definitely who should apply for registration? The owner should apply for registration. So, you should know who is the owners, then you will be able to trace that who will apply for registration of the copyright if registration is as such required. Then okay. So, different case specific studies also you can create regarding the authorship and ownership. Just like say when you talk about copyright infringement part, just like say there is important stories are there, just like say just like New Delhi movie or New Delhi kinds of situation. Let's say a case hypothetical situation. Let's say Mr. Y has written a drama. Now he want to convert that into cinematographic film. So, he asked somebody and tried to show him the drama in a particular theaters that drama. Now out of that drama, that person whom he called later on, he without taking permission, he was converted into a cinematographic film. So, I can whether it can be considered as adaptation. Okay. So, now if now that the creation of the producer is substantially different from that of the creation of the drama, then it will be again considered as original work. The substantiality will be decided based on the facts or circumstances. Just like say that whether it is coming within the purview of copying of facts or other elements, that will be decided situation to situation specific. Okay. So, that authorship and ownership part you understood partly. Now, registration and registration procedural components. Okay. So, if you if you read Indian Copyrights Act, I say that say it is referred that copyright there is no common law copyright. So, copyright means common law copyright, and copyright whatever the statute means Copyright Act will be provided, and that as per the act copyrights will also will subsist. There is no common law copyrights. Okay. So, now how to create right? Just like when I discussed of the patent, where I told you one component is called creation of right. Okay. So, how to create rights? The act suggested that copyright subsists by virtue of its creation. So, then whether registration is required or not. If you create some work by virtue of creation or publication, copyright will subsist on that work. But why there is a requirement of registration? Registration, copyright registration is also there, registration procedure is also there. But registration, because registration by virtue of that the work will be registered in the Copyright Office, and you will get a copyright registration certificate from that Copyright Office. So, it will be a valid proof in respect of your ownership with reference to the specific work. If some litigation arises, then this will be a valid proof. Otherwise, you have to you have to ultimately just like say you have to just like say you have to extract some evidences with reference to the authorships. This is a valid evidence with reference to the registration is a valid evidence for authorship and ownership. Okay. So, copyright subsists by virtue of creation and or publication. So, here I will again give you an idea of three categories of work you may consider if something is unpublished. If something is published instead of authors by published by somebody, what is the situation with reference to those kinds of work? Sometimes is called anonymous work, pseudonymous work, posthumous work. If just like say author is unknown with reference to that work, there is some procedural aspects also. In that case, that authors and when author is the first owner, then in that case you have to publish that, you have to serve a notice regarding that work in a newspaper widely circulated in that particular region, so that say that stating that okay, anybody have a right with reference to that work I want to publish that work. So, understood that okay, that by virtue of publications, if some name or pseudonym is there, there is the issues, or to identify the actual authors and owners of that work. Okay. If so, in that case, the procedural aspect suggested you have to be just like say published a survey notice in a local newspaper circulated in that area to trace that authors and owners of that work, authors and owners of that work. Okay. So, copyright means if you want to register the copyright, there is a procedural aspects with reference to registration of the copyrights. So, who will apply for registration of the copyright? I will say the owners. Owners means owner by virtue of assignment, owner by virtue of maybe sale, owner by virtue of your employee employer agreement. Okay. So, now let us say consider with reference to the IIT Kharagpur. Okay. So, now let us say some professor has written a software. Okay. Has written a software. So, okay. In software we can consider one element is the source code. Okay. Regarding software copyrightability, we will later on discussed regarding that what will be the elements of copyright protection within the purview of software, means whether source code, whether structure sequencing, or other part. Okay. Just like say consider software, definitely we have a source code in that software. Okay. So, now he wants to register that copyright. So, professors means let us say now analyze that professor is under employer employee agreement with IIT Kharagpur. So, who will be the owners with that software now? So, the software ownership should go to the IIT Kharagpur. Okay. So, now who will apply for copyright registration? So, copyright registration that IIT Kharagpur as an applicant will apply for copyright registration. Where he will apply? The Copyright Office. Where it is? It is under the purview of Ministry of Human Resource Development, is only with MHRD and at Delhi, but Delhi and specifically now considering today's situation. So, it is Delhi, only one copyright registration registered office. So, how will apply? There is corresponding forms he will apply in the with respective fees, forms referred, who is the applicant and who is the authors. Then he has to give the evidence of the work. If it is a software, he has to provide the CD and containing the source code of the softwares He has to give a name of your work, just like say a software or a database for weather monitoring, or a database software like this way. Sometimes he has to give the language in which he has written that software, just like say he has been using MATLAB's particular version, or C++, he has to refer the language. Then which class of work software, I refer already literary work. So, work title, language, along with the content of the work he has to provide, and the fees for literary work, very nominal fees is there. Then and he has to provide along with the applications also a no objection letters. It may be later on communicated, but generally it is advisable to submit along with the application form. So, no objection from the authors will write that we have no objection with reference to the work to be registered in the name of the applicant. So, application form, no objection letters, and work itself you will submit, sent to the Copyright Office. They will may check the mere formalities, they check the formalities, just like they will not check per se the originality and examine, they may do formal examinations with reference to the work. Then it will be registered, not so much stringent procedure, just like patent, just like in patent we have just like publications, all sorts of things. So, not like that, it will be registered based on the work. Okay, so corporate understood. Corporate registration is not compulsory, but if you register, that will be a valid proof regarding ownership and evidence that your corporate registers will reflect the ownership and the class of work, and certificate also will give an evidence of ownership with reference to that work. Okay. So, in respect of US also, there is no requirement for registrations. So, here also based on the creation and publication, work will be protected in USA also. So, but US corporate there is a procedure, just like say if you want to file an infringement suit in USA with reference to the work, then owner first have to register, then only can file infringement suit. You understood? That's the procedural aspect little bit different. Means you have to first register, then can only file an infringement suit. You can enforce your right in USA. In India, that is not there. The owners can file an infringement suit because right somebody can acquire right based on creation. So, you can consider creation and registration is the method. Creation and or registration you can put is the method to get a right with reference to the copyright. Creation and or registration is the methods. Definitely creation and registration, or creation and publication is the method for getting rights in respect of copyrights. Okay. So, copyright registration is not compulsory, but registration will give some sorts of advantage with reference to evidential component with reference to the copyright. So, how to register the copyright you understood? Understood. The copyright will be register. Now, we can say use your copyright, transfer your copyright before that also, after that also. The copyright can be transferred to the assignee, or by virtue of sale, copyright can be transferred to another owner. Okay. So, copyright registration procedure we are discussing. So, we also discussed about the author and owner, that is the one important parameters with reference to the copyright part. Okay. So, just like registration procedure with reference to the copyright you understood partly, and you understood that authors and owner another component for the copyright part. Okay. So, just like say this module I kept it for the procedural aspect, although procedural aspect is very simplified ways. That is the typical workflow you may not be properly represented. That is, I have copied it from the corporate office sites. So, it is not clearly visible, but this is the workflow chart they have been provided with reference to the corporate office. So, here also just like say if I consider the administrative procedure with reference to the copyright, we have a corporate office just like say corporate office. They sometime we call corporate boards try to address the various issues with reference to the licensing and corporate ownership type of issues also, and also related issues related to the anonymous or posthumous work. Corporate audit, there is a corporate registers is there, just like say they are just like a patent administration I have not mentioned, but they are we refer controller general, assistant controllers, deputy controller. Here only one corporate registers are there, and there is a corporate board, formation of corporate board, although that is not functioning, non-functional nowadays. The corporate board can sit depending upon the situation arises in the different places. The corporate board is also there for administration. So, corporate administration you can consider that corporate boards and corporate registers, and the corporate office is the at Delhi. So, that administrative part you understood the reference to the copyright specifically. Okay. Let us close this class now. Okay, thank you.